Hi, this is Rick Frederick, reviewing the case of U.S. v. Dubray, 1988, 8th Circuit Court of Appeals case. Dubray is not a great case, not a very important case. It's just an 8th Circuit example of the distinction between moral and criminal wrongfulness. And it concerns a young man who assaulted a 60-year-old nun in her home. What's important to know with respect to Dubray is that he had engaged in a similar activity, raping a nun, a few years earlier. Doesn't have a history of mental disorder, but he presented an insanity defense. The testimony from the victim indicated that there was no psychosis present during this assault. But a psychiatrist said that he had the potential for a transient psychotic episode, which could have produced a moral and cognitive break from reality. So very speculative testimony. He appealed on 3 issues. First, does the presence of a transient psychotic episode constitute insanity? Was the court required to explain the distinction between criminal and moral wrongfulness to the jury? And did the government's expert witness violate the federal prohibition on ultimate opinion testimony when he refuted the defense psychiatrist's opinion that Dubray had a psychotic illness? And the 8th Circuit Court of Appeals said no to all 3 of these questions. And as you would expect, the 8th Circuit said, look, just the mere presence of a mental disorder is insufficient to constitute an insanity defense. Even in the Durham rule, which was the most generous rule to defendants, the behavior had to be the product of a mental disorder. It never said, look, if a mental disorder exists and the person gets a free ticket on any behavior. And so under the ALI, it's the mere presence of mental disorder is not exculpating. The second argument was that the trial court should have instructed the jury regarding the distinction between criminal and moral wrongfulness. And similar to the 9th Circuit Segna case, the appellate court says, look, there's no need for instructions that aren't relative to the evidence that's been presented. So the instruction should be presented only when there's a meaningful distinction between the 2 appreciations of wrongfulness. And finally, the court rejected the argument that the prosecution expert addressed the ultimate issue. Even though the expert's testimony clearly undercut Dubray's insanity defense, as is obvious. This is true for all expert testimony. All expert testimony should be probative, speaking to the issue at hand. The government's witness testified to a medical question before the jury, which was psychosis, and not to the legal question of sanity. A pretty straightforward case, not an important case, but showing that there are issues with respect to wrongfulness that are addressed out there in the district courts. Thank you.